A very good afternoon, ladies and gentlemen. Thank you for tuning in. Hope you are having a pleasant day. With that, I would like to welcome everyone to our first ever episode of the Real Talk webinar, brought to you by the Excel Academy of Real Estate. Whether you are a seasoned pro or just dipping your toes into the real estate world, the Real webinar is your golden ticket to you learn from industry experts who have navigated the ever-changing real estate landscape, gain access to their insider knowledge, and stay ahead of the curve with up-to-date market trends. Joining us today, we have Mr. Mark Goh, who is a non-practicing advocate and solicitor of the High Court of Malaya, to speak on the topic of navigating the conveyancing maze, essential knowledge for real estate agents. If you have any questions for Mr. Mark, feel free to leave them in the Facebook comment section below, which we'll address in the Q&A section at the end of this show. Without further ado, join me in welcoming Mr. Mark Goh. Welcome, sir.
Thank you. Thank you. Thank you, everybody. I've entitled this Navigating the Conveyancing Maze because as I teach estate agents, they have asked me quite a number of questions, and these questions or inquiries come repeatedly, same questions. So I thought of just giving an overview in a series of conveyancing land law issues, but I'll introduce a overview of the conveyancing maze. What do estate agents need to know? Right? So this is basically my qualification and my professional position, which I have held. As well as some of the publications and presentations which I've made. Okay, I publish occasionally, not all the time, but occasionally in some of these publications. Now let's move into the topics. The topics I'll be covering are as follows. Basic conveyancing terms. Estate agents usually ask me, what is the difference between this term and that term and this term? So I thought of just giving an overview of the basic terms that they usually ask to explain what these terms are. So you are better when you are dealing with your clients. Legislations governing conveyancing transaction is an overview so that you know what are the laws that governs conveyancing transactions that would cover a bit of property law, which I've studied, as well as law and taxation, which I've studied. I will also give you an overview of the different types of conveyancing transactions. This is important because as your client approaches you, you're the first point of contact for the client, the buyer or the seller, and he will definitely ask you certain questions. So it is good if you have some basic knowledge of what happens after you complete as an agent, you complete your part. They won't only ask you, they will also ask you, so what happens after I sell? What is the legal process? Blah, 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 so on and so forth. So if you know a certain background or certain basic processes of conveyancing transaction, you can at least give them an explanation, some basic explanation, and leave the rest to the lawyers. And I will also go through a typical conveyancing transaction. What goes through in a typical conveyancing transaction? Now let's look at the basic conveyancing terminologies. So what is conveyance? Conveyance basically is an act of transfer of ownership, right? Conveyance can come in various forms, which I will look at it later. It can come with very typical buyer and seller. Okay, S&P, sale and purchase agreement. That's a conveyance. Okay, transfer and transmission, that's another conveyance. The person dies. Auction is another conveyance, right? So there are a couple of conveyance or act transfer of ownership or interest. A charge is a conveyance as well. Mortgage, which you don't use that. Then you have this word called seller, vendor, buyer, purchaser, depending. Okay, so the seller is the person who is selling, buyer is the person who is buying. I think we all know that. Now, this word encumbrance is a legal term, though. Okay, sometimes you hear lawyers using the word encumbrance. Is this land encumbered? This land is free from encumbrance. This land has got encumbrances. What do you mean by the word encumbrance? it means that there is an interest or a caveat, some kind of interest, which means in layman's terms, the title is not clean. Okay, it's not a clean title. There is some kind of is there is some kind of it's tainted to a certain extent. Tainted. There's some kind of interest. You know, it could either be a charge, a lease, an easement, or a caveat. So when you hear the word encumbrance, oh, this title is encumbered, then you need to ask further. Or at least you know. If you don't need to ask, at least you know, oh, this land is not a clean title. There is something on this land. And further investigation may reveal, like I said, whether it's a charge or a caveat. Right? A title that has got no charge or interest is a clean title. What you call it as clean, we call it as an unencumbered title. Okay, or another word, free from encumbrances. Then you have this word redemption. Okay, redemption means you redeem. Redemption sum. I think that's very common, right? We hear word. How much is the redemption sum? What is a redemption sum? Redemption sum means it's the amount that you need to pay off the loan or a charge. Notice I use the word mortgage. I close and open inverted comma mortgage, because in Malaysia we don't use the word mortgage. Okay, this is the amount that the borrower or the charger needs to pay off his loan to clear the charge, right? So that's the redemption. He needs to pay off. So when he pays off, guess what's going to happen? The bank will take away the charge. Barring anything, the title will be unencumbered. So long as the charge is there, typical scenario, the title will be encumbered. Okay, so that's the redemption sum, amount owing to pay off. Next. This word, boomy lot. Students always ask me this. Okay, estate agents always ask me this, come and approach. Hey, Mark, what's the difference between boomy lot and Malay reserve land? Does it mean that boomy lot you cannot transfer? Does it mean that it is only given to Bumiputra? Does it mean that I cannot transfer it? Okay, let me just go back. Let me just hit at Bumi lot first. Let me just discuss Bumi lot. Okay, Bumi lot. What does Bumi lot means? Bumi lot is a normal title. Okay, it's just like any other title. The thing is, for Bumi lots, before the developer gets the authority to develop or permission to develop a particular development, the state authority will impose a condition. Basically, the state authority will tell the developer, this lot, so for example, the developer wants to build 100 houses. The state authority will say, okay, we will approve this development provided and on condition 20%, 20 of the houses must be sold to Bumi Putras. Okay? If not, we're not going to approve it. So what the developer does is he will set aside 20 units. So this 20 units is only to be sold to Bumi Putra. Now, these 20 units they must be sold to Bumi Putra first. So the first purchaser must be a Bumi Putra. Thereafter, it can be non-Bumis already. But if you check the title is a normal title. It's just like any other title. We shall come to that. Okay, there's no chalk on the title that says it's a Bumi Putra lot. No, it's just a condition. Now, I have people also asking me, hey, Mark, if, there are some who say, hey, this one is a Bumi Putra lot, but sometimes the property cannot be sold off one, right? Sub-sale also cannot. You say first transaction cannot, sub-sale also cannot. Well, sub-sale cannot. Why? Not because it's a Bumi lot, because there is a restriction in interest on the title. Because the title has a restriction in interest. Okay, so if the title has a restriction in interest, the state authority may not allow. So it's up to the state authority to put the condition, right? Or the state authority may allow in certain situation, right? So the fact that it's a Bumi lot doesn't mean it is only limited to Bumi Putra. Non-Bumis cannot buy. No, this is only for first transaction. Developer to purchaser. Subsale all, no. Provided on condition, there is no restriction in interest. Okay, and the restriction in interest is not very specific. If not, that's normal. Now, this is different from a Malay reserve land. Malay reserve land is called Tanah Rizab Melayu. This one, Malay reserve land, is only for the Malays. It is stated on the title one. This one cannot. Right? Malay reserve land can only be transferred to Malays or any person specified in the respective enactment, because Malay reserve land is governed by specific state enactments one. So for example, Kelantan. Kelantan has a lot of Malay reserve land. Okay, they call it Tanah Rizab Melayu. It will be the title itself will show it's a Tanah Rizab Melayu. You look at it, you know you cannot already. So Tanah Rizab Melayu can only be transferred to a Malay. Okay, which is defined in the federal constitution. A Malay is defined not by race, just to tell you, it's by custom and it's by religion. Okay, if a person is a Muslim and he practices the Malay custom, he's a Malay, right? So if it is a Tanah Rizab Melayu, it can only be transferred to Malays or any person specifically stated in the respective enactment, right? So this one is only in the hands of Malay. This is completely different from Bumi Lot. Bumi Lot is just a normal title. Okay, so don't get confused. It can be given to a so-called non-Bumi, right? So these are the definition I would like to give. Now, next one, leasehold. Leasehold land. Just hold on. Leasehold land. Okay, what is this thing called leasehold land? Now, leasehold land, point number one, please take note that this is a layman's language. It's layman language. Leasehold land doesn't mean it's a lease. Okay? In a legal term, in legal terminologies, when the state gives the land to you, what we call alienate, the state transfers the land to the individual in two ways. He can give the land to you for unlimited time. Means he can give it forever. Means the state can give you the land and you can hold on to the land forever. This kind of land, it is legally speaking, it is called in perpetuity. In perpetuity. What the layman call it as freehold. Okay. Another way the state can give you is the state can give you the land. They give you the land for a specific time period. The legal terminology for this is for a term of years, usually 80, 99. It used to be 99 years, right? Now it's 80, but I want you to reapply. Now, this is not lease as it means lease. What they do is they give you the land for a specific time period. Say, for example, 80 years. After 80 years, you must return the land back to them. Okay? You must return the land back to them. That is called for a period of time, term of years. Now, this is different from the word lease. The word lease means the state authority actually rents out the land to you. The state authority is still the owner. For a term of years, or what the layman calls it as leasehold land, is actually not lease in what we mean. It's leasehold in the sense that they give you the land. The land is yours. You can do whatever you want with the land, but it's only for a term of 80 or 99 years. If it is a lease, you cannot do anything with the land. You are an occupier, the state is the owner. If it is a term of years or leasehold land, you are the owner. Okay, right? So these are the terms that causes confusion with estate agents and laymen alike. Now let's look at some of the legislations that govern. These are some of the legislations I just run through, right? National Land Code. In a conveyancing transaction, you need National Land Code. These are the main transaction. Okay, because land is involved. Contracts Act. Why? Because agreements are involved. You sign sale and purchase agreement. Agreements are involved. Contract is involved. Oral or written, Contracts Act is involved. Real property gains tax. You all know buying and selling a property, taxation, right? Within 5 years and all that. How much to pay, whether there's any exemption, zero tax, and all that is governed by the real property gains tax, right? Stamp Act, the government requires all documents to be stamped, or what we call adjudicated, stamped. So how is Stamp Act involved? Because we sign sale and purchase agreement, because we sign loan agreement, right? Sometimes power attorney comes in, right? All these documents, deed of assignment, leases, right? All of this conveyance, you need to stamp. If you don't stamp, you all know, not admissible in court. So you need to stamp within 30 days, within a certain number of days. Housing Developer Licensing and Control Act, you're aware of that. It only comes in when the property is sold by the developer to the individual. Once it's subsale, Contract Act governs. Okay, developer to first purchaser, HDA. Strata title is applicable to what? If it is a condominium, apartments, or strata will come in. If it's landed property, now also strata comes in, right? Okay, landed property. If it is a full gated and guarded area, you all know that if it's full gated and guarded, strata title comes in. Strata management, very popular. You have a whole list of people discussing on that already. How you manage the condominiums, the gated and guarded. And you have your solicitor's remuneration order, latest 2023. Why is this important? This is where we charge our money. Okay, right? So these are the main legislations that governs. Then you have other incidental legislations that we need to know. Companies Act, why? Because if the company is buying and selling property, Company Act needs to come in. Director can sign this that. Finance Act is connected to the RPGT. Okay. Then you have the Income Tax Act coming in. Why is the Income Tax Act important? Because if you buy and sell one or two properties, that's okay. It's under rental income. It's under profit, RPGT, correct? Buying and selling. If the government sees that there is a continuous buying and selling, they will take it that there's an income, not RPGT. If they take it that there's an income, bam, income tax comes in, right? So you need to know when to dispose, how much to dispose at any one time. You dispose more than 3 to 4, income tax can come in and say, because this is an income different. What's the difference? Because the tax regime for income tax is different from RPGT. The tax regime for income tax is higher than real property gains tax, right? And up to a certain amount, after 5 or 6 years, RPGT 0. Income tax, they can claw back one, right? So that's the difference. Land Acquisition Act, it's incidental because sometimes after buying and selling property, okay, after you have bought already, government comes and acquires a property. So that also we need to know. Insolvency, to a certain extent, is important. Why? How is it important to you and I, estate agents? How is it important? You sign the guy, you got the seller in or the buyer in already. He agrees to buy. He doesn't know he's a bankrupt. Neither do you. Matter goes to the lawyer, pushes it to the lawyer already. We do a bankruptcy search, finds out that The party is a bankrupt. Then how? That's an issue. That's definitely an issue already. Okay? Because some people don't know they are bankrupt. Do bankruptcy search when you realize. Then you have issues. Can sign the S&P or not? What's the effect? Who's going to take over? Can I sell? Power attorney. How does this come in? Give you a very common situation. Mr. X migrates to Australia, stays in Australia for 2-3 years, got a lot of property in Malaysia, wants to dispose it off, ask a family relative or friend to do it for him. Can the family and friend do it for him? Uses the PA lah. So he's got to restrict the PA, cannot simply give too much power on the PA. Right? Sometimes the PA can also be given to an estate agent, right? Right? So we need to check if the guy says, I'm selling on behalf of Mr. So-and-so, but he's not here. He's in Australia. Where's the PA? Power attorney. Okay? That's just an example. So these are the acts that we need to go through. But like I said, it's not exclusive, it's not extensive. These are the main ones. Okay? Right? Now let's move on to the types of conveyancing transaction. Now there are a couple of conveyancing transactions. The most common that we all face, I know we all face, estate agents face, is a transfer of property. Transfer of property, you got a lot. Not a lot, quite a number. The most common is a sale and purchase. Buying and selling of house. Now, there are 4 quadrants for the buying and selling of the house. This is what I'm going to go through with you. I'm going to run through these 4 quadrants of the buying and selling of houses. Okay, it can be either by the individual or the company. The cleanest one, the first quadrant, is where the vendor, whether he's got title or no title, irrelevant. Okay, where the vendor's title is unencumbered and there is a cash purchaser. This is the easiest, which means seller has clean title, buyer buys by cash, no loan. Simple. This kind of transaction is the easiest. Okay, clean title, cash buyer. Second scenario, a bit more complicated because for this there are only 2 parties involved, buyer and seller. Scenario 2, you have the seller, clean title, but the purchaser takes a loan because it's not cash purchaser. So when the purchaser takes a loan, you have a third party coming in, which is the bank. Because the purchaser needs to pull the bank in and tell the bank, hey, I want to borrow money from you to buy this land. On the flip side, you got the third one. C and B is the flip side of it. Okay, cat and boy is the flip side. You have the seller vendor with an encumbered title, which means the title has a charge one. Okay, because you have an interest one, I told you, if it's an encumbered title, you have a charge. But the purchaser wants to buy the land. Can. You also have 3 parties. You have the bank, the seller, the buyer. It's just now the bank is with the seller. Okay, because the seller's title is encumbered with a charge, but the cash purchaser wants to buy, the buyer wants to buy, right? So the bank will be tied out with the seller. And the most complicated of these 4 is D. For D, you will have this. I won't say it's not common, it's quite common also. Seller with a charge. Seller's land has a charge. Buyer taking a loan. So you got 4 parties here. You got seller, seller's bank, buyer, buyer's bank. So 4 parties. So how are we going to maneuver through all of this, right? More parties technically is more complicated. Less party, less complicated. Got people means complicated already. Let's take the first one. The first one is easy. Clean. This, if you have this, is cleanest. Seller, clean title, cash buyer. So first transaction, buyer pays cash, seller transfers the title. Of course, there's a lawyer here involved. You can either have two lawyers, buyer can have his own lawyer, seller has his own lawyer, or you can have one lawyer. I'll come to that later. What you all will usually call as common solicitor. There's no such thing as a common solicitor. Anyway, there is one lawyer that will handle it. Right? So buyer will pay the lawyer, who is a stakeholder, the cash. He will transfer it to seller, and at the same time, actually will hold on to it as a stakeholder. He will then transfer the property, present the title to the land office, wait about 7 days, everything clear already, withdrawal of caveat all done, present, wait about 7 days, 3 to 7 days, release the cash to the seller. Hold on, I'm sure you all know, hold on a small amount for RPGT. Okay. Now, next, you have seller who is selling the land to the buyer, and the buyer is not paying cash. He needs to take a loan. So we have a buyer's bank coming in now, right? So what do we do in such a situation? After signing the S&P, everything, the buyer will pay what we call the differential sum. He will pay in cash. Now question, what is a differential sum? A differential sum is the sum which the buyer has to top up to meet the price of the property. So say, for example, the buyer agrees, let's say the sale and purchase, the seller agrees to sell and the buyer agrees to buy at 100,000. Make it simple. The property is worth 100,000. Buyer agrees to buy at 100,000. Buyer applies for a loan. The bank will only approve 80% of the loan sum. Okay, 80% of the loan sum. So the bank will only release 80,000 to the seller, which means the buyer has to pay the 20,000 himself. He has to come up with the 20,000 to pay the seller. That is called the differential sum. Okay, that is called the differential sum. So the buyer will have to pay first. The bank is not going to pay. So the buyer borrows 80,000. The buyer will have to pay the 20,000 to the seller, the differential sum first. Once the seller or his lawyer receives it, when I say seller, buyer, I'm talking about their lawyers. When the seller's lawyer receives it, he confirms, he tells the bank's buyers, I have received the differential sum. You can now release the loan amount, 80,000. So 20,000 must be paid first. Seller lawyer holds on to it, informs the buyer's bank. Tell the bank, hello, buyer already paid the differential sum. You may now release the loan amount. Buyer's bank releases the loan amount. Seller's lawyer holds on. Now the seller's lawyer has the whole 100% cash. He will then transfer the title. Notice it doesn't go to the buyer. Where does it go to? It goes to the buyer's bank. Right? He will deposit the title with the buyer's bank. The buyer's bank will then, what will the buyer's bank do? Present the title, the charge, the withdrawal of private caveat. Okay? The buyer's bank withdrawal of private caveat, present all that into the land office, then they will go, then the buyer will keep. So at the end of the day, the title is going to show, what is the title going to show? Property transferred to the buyer, simultaneously charged entered by the buyer's bank at the same time, at the same date. Okay, so this is what's going to happen. Third scenario, flip side, seller and cash buyer. What do you mean by this? Seller's title is encumbered, which means seller doesn't have a clean title. The seller doesn't have a clean title. He's still paying his housing loan. Very common. He's paying his housing loan. Now he wants to sell the house. Then buyer comes in. Okay, I want to buy. Okay, sign the S&P already with the buyer. So the buyer say, I want to pay. Buyer is paying cash. Buyer is paying cash. Buyer said, I'm going to pay how much? Now what's going to happen? Seller's bank is going to tell the buyer. Say, for example, seller say, I'm going to sell you at 100,000, but I owe the bank 80,000. I'm going to sell. My S&P price is 100,000. Buyer agreed to buy at 100,000. The buyer will then buyer's lawyer will write to the seller's bank. How much does the seller still owe you? Oh, seller still owe me 80,000. Now the buyer is not going to give the whole 100,000 to the seller. The buyer is going to give 80,000 to the seller's bank. That is the redemption sum. Remember I told you? Redemption. Why he needs to redeem? Because that is the amount owing. So when he pays the redemption sum, the seller's bank, who is holding on to the title and the charge, since they're paid in full, they will discharge. And he will pay the balance purchase price to the seller. The seller's bank will release all the documents because they are not interested anymore directly to the buyer. The buyer will discharge the charge, the bank's charge, right? And immediately do a transfer to himself. Bank takes the money, he will release the document. He will release it directly to the buyer. Balance purchase price paid to the seller, done. Right? And finally, the last one, the most complicated, is if you have 4 parties. Seller still owing money to the bank, encumbered, didn't pay off yet. Buyer wants to buy the property, need to borrow money. So what is going to happen? Buyer's bank will write to the seller's bank. Let's say they agree fixed amount. Let's put it at 100,000. Let's not change the amount, 100,000. Buyer go and borrow money, sees his bank. The buyer's bank will ask the seller's bank, how much does the seller owe you? Oh, seller owes me 80,000. Buyer's bank will pay the seller's bank. Then the buyer's bank will then pay the balance purchase price to the seller. If there's any redemption, if there is any differential amount, buyer will pay the seller. I didn't put that. If there's any differential amount, buyer will pay the seller first. Balance purchase price, buyer will pay, buyer's bank will pay the balance. And once all this is paid, notice it doesn't go to the buyer. Everything will go to the buyer's bank. The discharge of charge, the entry of the charge, the withdrawal of the private caveat, the withdrawal of private caveat, transfer, everything will go to the buyer's bank. Buyer's bank will present it to the land office. Everything settled. So what will happen? Once everything is paid up, you will have the property being transferred to the buyer with the buyer's bank charge entered in, and at the same time, the seller's bank discharge is being discharged. The seller's charge is being discharged. So you have a discharge of charge, the entry of the buyer's bank charge, and the transfer to the new buyer's name. This one is the most complicated of all 4 because that's why the timeline have to run, the timeline. That's why people are rushing. Okay, because they got 4 parties which involve 4 lawyers. That's why the deadline comes in one. And satu kali we bypass the deadline, go extension, it was okay, right? Now, other types of conveyance, so that's a very common conveyance, sale and purchase. Other types of conveyance will be auction. Auction is another type of conveyance. Then you got developer sale, right? Developer sale is not S&P, it's governed by their own. Then you got death and devolution is another conveyance, transfer and transmission. The person passes away, has a will. Okay, father passes away, has a will, want to transmit it to the children. That's a separate thing because there's no S&P involved. Okay, the S&P will only involve if pass to the children and the children then wants to sell the property. Then you move on to the conveyance or S&P. But when the person passes away, transfers to the beneficiary, that's under death and devolution, that's a different type of conveyance. Okay, it's a different type. It's not under S&P. And then you have other types of conveyance, leases, tenancies, right? It's another type of conveyance. And charges are, okay, also known as mortgages. We don't use the word mortgage, but charges. Okay, now let's look at a title. Now, again, this, I won't say it's important, but it's useful to you. When you see a particular, sometimes the client, the seller will give you the title, I know estate agents, they just give you the title. What is this title about? Because you are the first person that the seller meets, the first stop before he sees the lawyer. So at least if you look at the title, you can advise. I wouldn't say advice. You can tell him you know a bit of what the title is. Don't look at it. Look at it, mong cha cha. Don't know this title. At least you know what the title is. Okay. Now I'm just going to show a very brief explanation of what the title is. At least you know. Now this one is a type of the title. This one is called hak milik sementara, which means it's a temporary title. There's no final title to it yet, no. Okay, this title to this land is not final yet. It's called, we all know as HSD, right? Hak milik sementara. Why? Because the state has not do a measurement of the title yet. Right? They haven't measured the title properly, the land properly yet. Right? They just give an estimate only. So is it as good as any other title? Yeah, it's as good as any other title. Once the state has done the measurement of the land properly measured and everything ready, then what the state will usually do is ask you to return this hak milik sementara. They give you a grant. A grant means it's already properly measured and all of that already. Okay. The boundaries, of course, the boundaries may vary a bit from the grant, the final title, compared to the temporary title. It may vary a bit, maybe more, maybe less. Okay, slight variation. But as far as legality is concerned, both are equally good titles. Okay, this the grant will be what we call a title in continuation. Title in continuation. And this one, you're aware, this is the quick rent payable. Okay, quick rent payable is value. They will value it, and then they will this one. This hak milik sementara mukim, this is actually the identity of the title. It is equivalent to what I call your IC, right? Your IC number is the same as this. This identifies what the title is. So this title is, this land is called HSM 571. It is found in lot 5071. Okay. And where is it? It is off Jalan Keramat, Mukim Ampang, Daerah Kuala Lumpur, Wilayah Persekutuan. That is how you identify the title. So it's like our IC right? They will identify it by your, what do you call that? Your date of birth, right? Then your locality, which state are you from? Then the number, right? You were given a specific number. Then I think you know, right? Male is odd, female is even, right? Same thing here. So that's how you identify the title. That's why we have to put it specifically. We have to check to make sure that these particulars are properly put in onto the sale and purchase, or else you're selling a different land. Okay. Now, see this? Grant untuk selama-lamanya. This is the tenure of the title. This one I'm trying to say. See this? Grant untuk selama-lama indicate that this title is given to you forever. If we call it is in perpetuity. Laymen call it as freehold, in perpetuity. Sometimes for so-called layman call it leasehold, they will put there, they won't put grant untuk selama-lamanya. They'll put 99 tahun, 80 tahun. So you know it's given to you for a fixed period. Right? That's the tenure. Next, you can see this. Daftar. This is the date the title is registered. Why is this important? This is important because that is the date you become the absolute owner. Okay, all this prior to 31st October, you're not the absolute owner. I'm talking about the first owner, When state gives to the individual, when the state creates a title, when the land is born, when the state, we call it as alienation, when the state gives, like when a person is born, you're given a BC, right? So your birth certificate will state the date that you're born. Same. So it's a date that the state authority gives you this, alienates this land to you. Okay? Right? Prior to that, you're not the owner. After this, you're the owner. All this is important because this is an endorsement of the registrar. The registrar endorses it, indicates that this is an original title. Okay, syarat-syarat khas. This one people will check. Special conditions. This is what I mean. Sometimes the syarat-syarat khas is nil. Nil, nothing to it. Sometimes what we call is special conditions. This is special condition. Okay, right? This has a special condition. Sometimes the land doesn't have a special condition. Sometimes the most special, the most common condition on the title is what? This land cannot be transferred, cannot be charged, cannot be released unless you get the state consent authority. Correct? Right? So that's very common one. And this one usually appears, I say not all the time, usually appears for leasehold, fixed period one, like leasehold title. Freehold or in perpetuity usually don't have one. Usually, sometimes they have one of the rare ones they have. That's why you got to check the title. Okay. Express condition. Express condition means that this is what you can do on the land. You see, it says this land described herein shall be for building only. So they will tell you what you can do on your land. Some will say this land you can only plant this, you can only do this. If they put there nil, then nil. Express condition is what you can do on your land. Not very relevant. And this one, restriction in interest. This is what you can do with your land. Sometimes it says, like I said, this land cannot be transferred for 5 years. This land can only be transferred if you get the consent. Okay? Right? Sometimes you look at it, got restriction in interest one. This land can only be transferred for 10 years with effect from the date it's registered. Then you better check when it was registered. Right? So these are all the particulars that as lawyers we have to look out for because it affects the title. Can you imagine if there's a restriction in interest and we never check properly, we present the title, kena tendang lah. Sure kena lah, you got restriction. Okay, this is the next page behind the title. The record tuan kepunyaan tanah lah. This one they will show you. Okay. This is 101, particular landowners. This is easy, you have full. Sometimes you have half, right? Half undivided share, quarter undivided share, husband and wife, setengah bahagian tidak boleh dipecahkan. Then you will know. So from the title you read, if your client gives you to, at least you see, oh, this one got two owners one. Why you want to sell? Who's the other owner? Why got half share one? Who's the other half share? Then it triggers, at least you can check. At least you can ask the guy. Right? Okay. So this one, 101 full. And then finally, this is the record urusan. Record urusan means the transaction. Okay, the transaction record. Right? Every transaction will be recorded from the date, the time the title is given. You see, the title was originally given previously. I show you, see? Here. This one here, can you see? Here, didaftarkan, this part here, 31st October. This is originally given. Then from then on, you will show this title was originally given to who. Then after that, all the transaction record. If it is transferred to X, it will put there. So if it was given to A originally, then A's name is cancelled, then you'll be given to X. Then X transfers to Y, Y transfers to Z. All the previous transaction all will be given. And for every transaction, the pendaftar has to chop. Because every time the pendaftar chop, only if the pendaftar chop, the transfer goes through or the particular transaction goes through. If the pendaftar doesn't chop, that transaction doesn't go through. Whether it's a charge, it's a lease, it's an easement, it won't go through unless the pendaftar has to chop it. Okay, so take note of that lah. This one is okay. This is basically how a strata title looks like. Strata title is a bit different from the individual title. Just now I showed you was an individual title. This is strata title. You will notice strata title has a type of title, building number, floor number, parcel number. They have all of these ones. So which building, which floor, which parcel. Okay, normal land title don't have. We don't have that one. Then the rest are the same lah. The particulars are the same. Okay, so this is a typical conveyancing transaction. Just show you. There's a pre-signing of the S&P, payment of the earnest deposit. So if the buyer sees, the estate agent comes, appoints, marries the buyer and the seller. This is pre-S&P, payment of earnest deposit first, right? Okay, payment of earnest deposit. Then they will sign the earnest deposit form and all that. So to appoint the solicitors within 7 days, 14 days. Usually, once the solicitor is appointed, again, up to the parties, whether you want to appoint, whether there's going to be one solicitor, whether the buyer wants to appoint separate solicitor, that one, people ask me, I say, depending lah. Okay? There is no, what I want to say is there's no such thing as a common solicitor lah. Okay, people go common solicitor, no such thing as a common solicitor. It's more like a tumpang thing. Okay, if the buyer, if as a seller you want to sell your property, I got people asking, so should I appoint my own lawyers or not? That would depend on how much your property you're selling it for lah. Okay, how much you're willing to take the risk lah. Okay, because if the buyer appoints his own lawyer and you tumpang the buyer, I know it's cheaper. You don't have to pay legal fees. You only pay legal fees for discharge only, right? Okay. You don't have to pay your own legal fees for the S&P. But then again, don't forget there's no common. It means that you are not represented. The lawyer is actually representing the buyer, not representing you. Don't think you tumpang is representing you. He cannot, because it will be a conflict of interest, man. So he will represent the buyer. He doesn't represent you. You are unrepresented. Right? So if the S&P is not properly read, and then at the end they say, hey, why is it like that? Not fair to me. Then you got no one else to blame but yourself. But sometimes people take risks because no need to pay what, correct? So when do you appoint? If you appoint a lawyer, you pay more. Okay? Pay your legal skill fees. Right? Depending. I mean, if the property is worth 2 to 3 million, I think it's not worth to tumpang. Okay? It's not worth to tumpang. It depends on how much you're willing to lose. Then after you appoint the lawyer already, then you got the issue who is supposed to, we will sort that out later. If buyer appoint lawyer, seller appoint lawyer, who is supposed to draft the sale and purchase? That one also got people fighting. Also got lawyers fighting. No lah, seller supposed to draft lah. No lah, buyer supposed to draft lah. That one was there. Okay. Then after that, let us say we take one solicitor. What's going to happen? Okay, let's say buyer appoints a solicitor, seller doesn't, he tumpang. The solicitor, the so-called common, open and close inverted commas, common solicitor will make a land search. So we'll do a land search to make sure that the title is according to what the seller says. Okay? Make sure there's no caveats. Or if there is a caveat, expected caveat. Satu kali sometimes you got caveats coming in, you know. So do land search and hey, why got caveat one? Never tell me anything. Oh, then suddenly the guy tells you, oh, sorry, I've got this issue with this person, that issue with that person. Yeah, it's like you never ask, I didn't tell you lah. Got lah like that. Clients got like this. Then we also make a bankruptcy search, common land search, bankruptcy search standard. And I told you already, sometimes you do a bankruptcy search, it will reveal that the guy is a bankrupt. The guy doesn't even know. The seller doesn't even know he's a bankrupt. The buyer doesn't even know he's a bankrupt. Then we got a whole set of problems coming in. Okay. Then once you do a bankruptcy search, if land is clear, the bankruptcy search title is clean, bankruptcy search is clear, prepare the sale and purchase agreement, then ask the guy to come and vet through first. Give you a draft sale and purchase, let the parties vet through first. After vetting through, amendment made here and there. In the meantime, while they are vetting, prepare the ckht. Okay, this one you don't really need to know lah. Cukai, real property gains tax, right? The form ckht 1, ckht 2. Prepare the memorandum of transfer, prepare the private caveat, prepare the withdrawal caveat, prepare consent to transfer. Consent transfer, no need to prepare all depending if the title has a restriction in interest saying that if you want to transfer, you need consent, then we need to prepare the consent to transfer. If the title is, there's no condition, no restriction in interest, then no need to prepare consent to transfer, right? Okay. Then after all these documents are ready, call the parties, come in. Can you please come in and sign the sale and purchase? So when they sign the S&P, they sign everything as well. Okay, so you notice you end up signing a whole lot of documents. Question, if you don't want to sign the other documents, can or not? Can. If you just want to sign the S&P only, can. Then every time we want to submit, we ask you to come back and sign lah. Which one you want only? It's either or only. So client know that, okay lah, sign all lah. Sign everything in escrow lah, easier. So during signing, pay the balance purchase 8% to the buyer. After that, immediately lodge a private caveat, okay, to protect the buyer's interest, because got evidence already, S&P. File the ckht, forward the 2% balance purchase price to the IRB, then get it stamped. Okay, get it valued first. Once it's valued, then stamp it after valuation. Then within that 3 months, the purchaser will go and borrow money or take whatever lah. If it's cash, then within that payments, it pays up lah. If it doesn't pay out within that 3 months, then you go into extension date, 1 month plus interest, K3 plus 1%, 10% per annum on a daily basis. He has to pay. If not, if he pays out the balance purchase price, no problem. Then present the MOT, withdraw the private caveat, then collect fees. Done. Okay, collect the balance purchase price, then do the apportionment. This is going to be another issue, right? So you calculate the apportionment. Okay, right? Who is supposed to pay what, quick rent, electricity bill, assessment, everything. Then finally, after apportioning, pay the seller the balance purchase price, deliver the keys to the buyers, close your file. Right? Okay, so that is a quick overview of conveyancing practice. Basically, we will move on to others as and when the need arises. Thank you. Any questions?
All right. Thank you so much, Mr. Mark, for that insightful talk. We will now move on to the Q&A segment, where you will hopefully clarify any questions you have on today's topic. So, for the first question, we have a question from 𝐲𝐸𝐬𝐘. What is the difference between Bumi Kota and Bumi Lot?
Ezekiel, can you hear?
Yes.
Yeah, it's the same. I just mentioned Bumi Kota is Bumi Kota, Bumi Lot is the same. We're referring to the same thing. So basically, what they are saying is that imagine the developer wants to develop a land. He wants to build 100 houses as his project. So he has to apply to the state authority first. Okay, he gets the approved permit to develop the land, APDL license to approve to develop. So the state authority says, okay, we will allow you to develop, we will allow you to build 100 units, provided and on condition 20 units is set aside for Bumi Putra. That's your Bumi Kota, bro. Provided 20 units is set aside for Bumiputra, which means these 20 units you cannot sell to non-Bumis. What about the 80 units you can sell to whoever you want, that's up to you. But these 20 units can only sell to Bumis. Right?
Right.
That is what it means. That is what you call the Bumi lot. Lah. So that's the quota. Right? Remember, already explained. So first transaction the first purchaser must be a Bumi. Okay? Must be a Bumi. It's Bumiputra, bukan Melayu saja. Bumiputra. So it's wider than Melayu. Okay, take note. Right? So once the first purchaser who buys from the developer, okay, he's a Bumi, he buys it, then the state authority will know. Why? Because I told you, right? The first title transfer from developer to the first purchaser has to be a Bumiputra. Once he buys it, the state will know already. Then from the Bumiputra, he wants to sell it to whoever he wants to go and sell. In the title, it's just normal only. It's just a normal title, that's all. The state will check
All
one.
right. Thank you, sir.
Okay.
Moving on, we have a question from Ms. 𝐤𝐶𝐚𝐲𝐽. Hi, Mr. Mark. What resources or professional organizations can estate agents turn to for ongoing education and support in the field of conveyancing?
Yeah, Shikin. That's why I've been teaching this, and I realize that's why they have been asking. That's why I'm coming up with a series. I really don't know what degree. Basically, it's law lah. Yeah. That's why I came up with this series on this, right, to help people like you, right, on this. I find that it's good because at least estate agents know behind, or some of them they usually don't know. Prior to that they won't want to know, or they don't know. That's why I'm coming up with this series lah. Okay.
All right. Thank you. Moving on, we have a question from Ms. Nazliana Nazaruddin. What are some best practices for estate agents to help their clients navigate and the legal aspects of properties and transactions?
Oh, okay. Okay, so Naziana, so best practices to help their clients navigate the legal aspect. Again, it depends on which client comes and see you. You got a lot of clients. Excuse me. You got clients coming from different types of clients, right? So if you have a typical client coming in, right, maybe you can ask questions like, this property. I actually have a checklist lah. That's for conveyances, but basically a checklist asking things like, so can I have a look at your title? You is there any amount which is outstanding? Any loan sum? Are there any caveats, or how do you manage to get? How many persons own this property? Sometimes they don't tell you. I know. This property owned by 2 to 3 different persons and all this. Do you have a loan outstanding? What's the loan amount? So on and so forth. So different people you have different questions. There's no one size fit all. You know what I mean? Right? Okay. But one thing good is you can ask them for their title and have a look at their title. At least you can advise them on their title.
Thank you, sir. Lastly, we have a question from Nur Atun. What advice do you have for estate agents in terms of managing client expectations and timelines in the conveyancing process?
Okay, wait. I see. Okay, now the timeline for the conveyancing process is quite tight. Usually, it's basically 3 months, right? 3 months. What you can ask the client to do is, if they come, ask them to number one, go and get their title first, right? Help them to read their title. Ask them to get a copy of the title. Help them to read the title. Ask probe information. Okay, how many people are there in this title? How many caveats? Right? So ask them. Usually they don't know, but now you know a bit like, oh, there's a caveat. Oh, is there a charge and all that, right? And then tell them you need to go and, you know what, 3 months is the deadline. You need to quickly go and apply for a loan. So ask them things like, are you a cash buyer or you need a loan? Are you a cash buyer or you need a loan? Oh, cash buyer, then you don't feel so tekan. Cash buyer, please get your money ready, sir, within 3 months only. From the time you sign the sale and purchase agreement, you only have 3 months. Please make sure your funds are ready. And if, let us say, they say that, oh, I need to get a loan, then you tell them, okay, once you sign this, can you quickly go and apply for a loan? You can start searching for a loan, because it'll take some time for them to look for a loan, because everybody wants to get the best price, right? So they need to go to 2 to 3, basically shopping lah. Go to 3 banks to go and shop here, shop there. So you can ask them, start your shopping now, because it will take some time. And mind you, if they start shopping, okay, a couple of things may happen. Number one, a couple of scenarios. They may not find the bank that they like, correct? Right? So they will take time. Number two, if they find the bank that they like, the product that they like, they may not qualify for it. Correct? The bank may say, oh, you're sorry, you don't qualify for this. Then kepala pusing pula. Got to go and look for another bank again. This take time one. Right?
Yeah.
Then another situation is they may agree. Third scenario, he gets the bank that he likes. The bank approves his loan, but guess what? He approves the loan not according to what the buyer wants. So the buyer is hoping for 80%. Bank say 60%. The fellow, I already planned for 80. How am I going to come out with the extra? I only prepared 20% differential sum. How am I going to prepare the second differential sum again? How am I going to come out? The bank said, sorry, I can only give you. Then like, you go and start all over again. You get me? So these are things that you have to look out for, You really have to look out for. You have to get the bank ready. In the meantime, although they will say, we don't, we got not enough information, we cannot approve lah. Some of them say we got no S&P lah. Well, tell them, okay, give an estimate. This is my S&P amount. Okay, this is my S&P price. This is the amount I need to borrow. Blah blah blah, so on and so forth. What are the chances? And always have a backup lah. Okay, always have a backup, because they can only act once you have a sale and purchase. You get me? So get it ready first. At least you have a backup. When the sale and purchase comes, once you have the S&P, once it's stamped, then you submit in. Then have one backup. Just in case the fellow say tak boleh pakai, then you quickly run to the other one.
Right.
Don't rely on one only. I say, oh, can, sure can. After that, they will turn back and tell you, even though if you say, but you told me can, what? You know what the officer is going to say, but he didn't give me all the documents, what? S&P never give me this, never give me. You say, but I'm not ready. Okay, now I'm ready. Now you're ready. You give me. I see. I cannot give you what you want.
Yeah.
Right.
All right. I think that's all the questions we have for today. With that, we have reached the end of this first Real Talk webinar. Once again, I would like to thank you, Mr. Mark, for the awesome talk you gave just now, as well as all the participants, of course, for tuning in today. We hope to see you in the next one. Thank you. Thank you, sir.
Thank you.